Hello all. In this video, I will try to address a very particular aspect of the entire debate surrounding the Citizenship Amendment Act, which is concerning how several states like Punjab and Kerala, to name a few, have openly registered their opposition against the CAA, and their respective chief ministers have declared that they will not implement the CAA in their respective states. Now, at the outset, this declaration seems to be a symbolic, uh, what do you say, a political or a moral statement in opposition to the CAA. That is the same impression regarding the resolutions recently passed by the Kerala and Punjab legislative assemblies demanding the withdrawal of the Citizenship Amendment Act. They don't have any binding effect. Anyway, so as we proceed, let us recollect that citizenship is a subject that falls under item 17 of the Union list in the 7th schedule of the Indian Constitution that regulates division of legislative powers. Thus, to make laws regarding citizenship is the sole authority of the Indian Parliament. However, when it comes to the execution of this law, or any law passed by the parliament, there is an involvement of our respective state governments and their agencies. In that context, let us try to think about it practically. How could states hinder the implementation of a union law like the CAA? Now, let's think about the possibilities. Firstly, district collectors slash district executive magistrates in charge of each district in a state are usually among the main state government officers or authorities which implement central laws passed by the parliament and which are monitored by the union government. For example, under the Citizenship Act of 1955, the main legislation which governs the matters of citizenship, and to which the CAA 2019 has made some changes. In this main legislation, Section 18 allows the central government to make rules for the implementation and grant of citizenship under the 1955 Act. Now, accordingly, the current rules that are governing are the citizenship rules of 2009. According to these rules, the district collector is the authority before which people will make applications for getting registered as a citizen in the normal course. Based on the report of the collector, what usually happens is, based on a report of the collector, the state government will make recommendations to the central government, which will, of course, then finally take a ultimate decision. Similarly, police officers of each state play an important role in implementing citizenship related laws because they are the ones who handle the arrest and deportation of unlawful migrants in most cases, and not central agencies like the CBI or the NIA or any other investigative agencies. Now, underline that police officers and district collectors, structurally and hierarchically, are under the control of respective state governments. Hence, a Pinarayi Vijayan or a Captain Amrinder Singh, practically speaking, might be able to instruct these authorities not to implement the directions under the CAA. This could be one way in which they could sort of practically block the implementation of CAA on the ground. But here is the catch. The Citizenship Amendment Act 2019, the CAA, has been quite smartly worded at one place. Section 6B, subsection 1 of the Citizenship Amendment Act states that as far as the processes regarding the grant of fast tracked citizenships to the religiously persecuted religiously persecuted migrants are concerned, the central government or an authority specified by it in this behalf will be the designated authority to receive and dispose of the applications made by eligible migrants. So, When the rules are later made under the CAA 2019, for which we'll have to patiently wait, the central government could actually designate authorities under the control of the central government over whom the states will have no authority to dictate as the responsible bodies under the CAA to implement it. Therefore, there is a possibility that the role of state government agencies like the district collector, can be nullified in the implementation of the CAA. Essentially speaking, the union government can conduct that exercise under the CAA on its own from Delhi if they choose to do so. Now, if such a scenario arises, these political statements by a Pinarayi Vijayan or a Captain Amrinder Singh will be really futile, you know, as they won't be able to block the implementation at the ground level. But for any further discussions on this, we definitely have to patiently wait till the time the Union Home Ministry notifies the rules under the CAA 2019. But for a moment, let us assume that the central government bestows the authority or the duty to implement the CAA upon the state agencies like the district collector or the police officers. Could then, in such a situation, a Pinarayi Vijayan then successfully obstruct the implementation as discussed earlier? This is where we must examine the constitutional setup of India's peculiar federal structure. So let's take a look at some of the critical aspects of this constitutional scheme. Now, Article 256 of the Constitution is the first provision that we need to look at. This provision acts as a general mandate on the state governments to exercise their executive power to ensure compliance with the parliament made laws. Meaning that states have a general duty to use their administrative agencies to implement and comply with the laws made by the parliament. This provision also, which is the most important aspect, I would say, this provision also gives the power to the central government to issue such directions to ensure compliance from the state as far as such central laws are concerned. Now, this is the general mandate on the states. Further, Article 257 comes in the neighborhood with a more instructive mandate on the state governments. It says that the state governments must exercise their powers so as not to impede or prejudice the implementation of parliament made legislations. So, these two provisions, there is one more provision which is Article 258, which I'll not discuss here, which is also in a way sort of combines to form a trio with Articles 256 and 257, which would act as a constitutional mandate on state governments insofar as their role in implementation of parliamentary legislations are concerned. The nature of these provisions act as a major constitutional hindrance on the states like Kerala, which have declared that they will not implement the CAA. Now, to slightly sort of move away from the discussion point, without reference to the merits of the CAA and the opposition against it, let me state that these provisions like Article 256, 257, 258, they are not anti-federal or coercive steps against the states that are embedded in the constitution itself. Such a scheme is necessary to ensure the sanctity of laws passed by the parliament. Otherwise, just consider a general and a normal scenario. Political differences at the center and the state level could hinder the smooth functioning of the legal system where laws are not implemented. So, these constitutional provisions, regardless of the morality or the lack of it, vis-a-vis the present situation regarding the CAA, it stands as a constitutional limit on the powers of the state governments to block implementation of the CAA or any other central laws for that matter. Besides these provisions, as we discussed, if we take a look at certain other provisions as well, we will get a better sense of why, constitutionally speaking, the states are helpless in this regard. Most importantly, Article 365. 365 takes off from the basis actually laid down by Articles 256 to 258. What this provision tells us is that it actually talks about the after effects of a state government's failure to comply with the mandate under Article 256 and 257. The impact of 365 is that, for example, if the state government does not comply with the directions under the laws made by the parliament, and let's say consequently refuses to implement it, or disregard the directions given by the central government to implement such laws, the President of India, of course, upon the advice of the central government, can deem it as a situation in which that state government cannot be carried on in accordance with the constitution's provisions. From here, it leads us to the much abused Article 356, under which such a ground as mentioned above, popularly phrased as breakdown of the constitutional machinery in a state. This is a very popular phrase that all of us would have heard. Now, this ground can be used to declare state emergency and impose presidential rule in that particular defaulting state. Again, so constitutionally speaking, the states are bound to implement any parliamentary law regardless of their disagreement with it. So, India does not really have a full fledged federal structure like they have in America, where the states can effectively and constitutionally block the implementation of several federal laws. And of course, I agree that it may be that as observed in cases like SR Bumai, any single act of violation of the constitution may not necessarily satisfy the threshold for deeming it to be a failure of the constitutional machinery in that state for an emergency or a precedence rule to be imposed under Article 356. Anyway, so before parting with this video, I would like to sort of point out or highlight a past incident from the 1960s, if I'm correct. Yes, 1960s, which attracted these above discussed provisions in a mild manner at least. So it goes like, in 1968, there was a central government employees strike. Employees of the central government agencies conducted a strike in response to which the central government brought in an ordinance making this strike illegal. And further, it asked the state governments under this law to arrest and prosecute any protesting employees who violate this particular ordinance. The then Communist Party led Kerala government refused to do so once again. The Union government, through its Home Ministry, had issued written communications thereafter to the then Chief Minister, Comrade EMS Namboodiripadu, reminding him about the state's obligations under Article 256. Interestingly, for the sake of a glossy satisfaction, I would say, the Kerala police arrested some protesters, but shortly thereafter, they withdrew all the cases against them. But I think the Union government did not take any further action, although they could have. As I said, Article 365 and Article 356 sort of takes off from the basis laid down by Articles 256 to 257. So that is all from my side. Part 3 of the series will be uploaded a little while later. Thank you so much.